start with, I'm going to ask Geoff Chambers to come up. Geoff's a board member and an attorney and an expert on a whole lot of important things. This morning he's going to talk about one near and dear to the clinic's hearts, and that's HIPAA. So, Geoff.
So I want to learn a little bit about you. And what I want you to do is raise your hand. And if you are associated with a clinic that provides medical services. Almost all of you. And now I want you to keep, I'm going to ask you some questions, and I want you to tell me, or basically raise your hand if it's your understanding that HIPAA does not apply to a free and charitable clinic. No one? There's an understanding out there that if you don't take insurance, then HIPAA doesn't apply to a free and charitable clinic. And technically that may be right. But there's some things that can bring you into HIPAA. And so I want you to raise your hand and keep your hands up if any of these things apply to your clinic. Have you ever helped a patient in your clinic get enrolled in Medicaid or Medicare or a similar program? Have you ever helped a patient? Keep your hands up. Okay. Have you ever helped a patient get enrolled in a drug benefit program such as like Well Vista? And all of you keep your hands up. Have you ever helped, or have you ever taken a sliding scale payment? Or does your clinic do that? Is your clinic a hybrid clinic? All of you with your hands up, technically, by law, HIPAA applies to your facility. And you're required to meet the requirements in the regulations. And what I may go through today may scare you. I don't intend it to scare you. If it doesn't apply to your clinic, these things are still applicable because it's best practice. So what I'm going to do today is I'm going to take a scenic tour of HIPAA and the different components of it, give you a little bit of familiarity with it. I'm going to talk about some cases, some real life things that happened in HIPAA enforcement. And I'm going to talk about something that the Free Clinic Association is doing when basically what that is every year we ask you for patient data. And as you know, you can't say that I saw patient X on October 11th. You have to anonymize that data. And so what you're doing in that anonymizing that data is actually, you're becoming HIPAA compliant. You're not giving us the personally identifiable information of your individual patients. And so we're going to talk about that a little bit. So HIPAA has really a number of components. I've listed them here. The important ones are related to privacy rule, the security rule, and the patient notification rule. The enforcement rule, hopefully none of you will ever have that. The good news is that there's never been an enforcement against a free and charitable clinic that I can find anywhere. So that's the good news. And you guys tend to stay out of trouble, and also you're not on the radar of the people doing enforcement, which is obviously the civil rights of government services. The privacy rule defines who can have access to information. One of the key things about the privacy rule is it is the patient's file. It is there. They have access, except for a few minor exceptions. They should have access to their records. People working in your office can have access to a waiver from the patient. You all know this. That's basically the main requirements of the privacy. This is the group of people that need to protect information. And what PHI is, or Protected Health Information is it is information about someone's health care or related somehow or obtained during the process of administering health care, which can personally identify an individual patient. And so if you're in any of these things, you're a healthcare provider, as I said, it may or may not apply to you, but you are a healthcare provider. Generally, if you were a traditional healthcare provider, it definitely would apply to you. You have to protect that information. Even if technically HIPAA doesn't apply to you, you should protect that information. Some examples of PHI are patient names, addresses, phone numbers, email addresses, a website that can be traced back to the patient, social security number, account numbers within your office even can be considered PHI if it could reasonably be used by someone to identify that particular patient. Dates, and this may be important to you later. You can't say that I saw a patient with tuberculosis on October 11th from Beaufort, Wyoming, and for a number of reasons. Beaufort, Wyoming doesn't have any people. You just said October 11th. And so if it gets out that someone was transported to your clinic by someone else in the community on October 11th, they pretty much know who has tuberculosis. Beaufort, Wyoming. Does anybody know where Beaufort, Wyoming is or know anything about it? It has a population. America's smallest city. So never say I saw somebody from Beaufort, Wyoming. So you have to think through these things and think, can it reasonably identify? Or could it be used in any way to identify the patient? And if so, don't let it happen. This technical definition, basically the second part is what I was talking about a minute ago. Is there any reasonable basis to believe that it could be used to identify the patient? And if so, you need to keep that private. If it's electronic, the security rule is going to apply. And the privacy rule defines how you deal with traditional information, such as paper charts, stuff like that. Your records in non-electronic format. If it's an electronic format, there are a lot of security safeguards that come into play in the security rule. And they're divided into technical safeguards. And technical safeguards are things within the software itself that offer protection. So if the software encrypts the data automatically, that encryption within the software, that piece of that software would be a technical safeguard of the data. Physical safeguards are where do you have your workstation? How do you, where do you keep the devices that access that information? Where are your servers? Okay. Can the general public walk in and get on that workstation? Can they see the screen number? That's a physical safeguard. Administrative safeguards, and these are very important because these are where most of the enforcement actions happen. Administrative safeguards are your policies. What is your policy on who can get on that computer? Okay. What's your policy on doing background checks on volunteers and employees before they have access to these records? So those administrative policies also safeguard the information, and usually we can do a very good job of coming up with a system that's technically safe, and we can put it in a place that's safe. Most of the data breaches actually occur because of some sort of human error. And these administrative policies are designed to protect that data against those type of errors, or in some cases, wrongdoing. The rules are either required, when you go through the list of requirements or safeguards, are either required or addressable, and very few of them are required. You may have heard, has anybody here ever heard that the encryption of the data is required? Raise your hand if you've heard of it. It's not required, it's what they call addressable. So if I have data in electronic format and it is on a computer that is not hooked up to anything else, and that computer is locked away from it, and there's no way to get on the internet and get that data, then I don't necessarily have to encrypt it. It's addressable. I would address the loss of that data through basically other means. So it's not required. There are other things that are required. An example is backing up your data. That is required. And we want to be able to make sure that that data is not lost. We're going to go ahead and require that you back it up. So you have required and addressable, and we divide them into these different I've covered that. I'll let you read my comment. This would be a physical safeguard. This also would be a physical safeguard. Technical safeguards, I've already told you what those are. If you have a disclosure or a data breach, there's a notification requirement. You have to notify the patient when the data was released. You then have to notify the HHS secretary. The forms to do that are on their website. There is a very embarrassing thing if it is a big data breach. You have to publish it in media. If it's over 500 individuals who've lost their information. You have to, don't publish the individual's name, but publish basically the date at which it was discovered, the date at which it occurred, how it occurred. And so you don't want to be in this category that is published. And HHS keeps a catalog of these that goes back to 2003. You can get on HHS's website and read who has had these big data breaches all the way back to 2003. And from 2003 to 2016, as long as HIPAA is around, if you're in that category, your name is going to be on their website pretty much forever. The omnibus rule beefed up the security and privacy rules. The main thing to remember about this is if you are contracting with somebody else, if you have some subcontractor coming in, they need to sign an agreement with you that says that they're going to protect this information for patients in the same way that you're required to protect it. Okay, even if HIPAA doesn't apply to your clinic, it's a good idea if you have somebody coming in that's going to see patient health information to have it in their contract that they're going to protect it. That's the main requirement there that has come in with the omnibus rule. Other things are minor and just basically adjustments to the security rule and strengthening them, but not really anything new. Just maybe making something a little bit more inclusive for other situations that weren't thought of back when the security rule was written, because technology has changed. And those advances in technology that we are seeing are, all of you know that you're being drug into the tech world with electronic medical record. It's going to be required for you. A lot of times we're storing things on the cloud. If you are storing something on cloud storage, you have a business associate agreement that cloud storage provider, because they have physical control of your data. And so the security rule would apply to that. And you must have that business associate agreement with them. Even if you encrypt it before you put it over here and they cannot look at it, they still have physical control and possession of that data. So you must have that agreement. We're seeing mobile device use in new and exciting ways. Basically, a physician has their cell phone. They're monitoring patients in multiple different rooms from basically an app in that cell phone. So basically, there's a problem if let's say they're in the ICU and they're in this particular room. That app in the cell phone might monitor 10 different patients and all the machines hooked up to them. If there's a problem, it'll alert them and tell them what it is, and we can pull up the screen on their cell phone and look at the output and the data. We're also seeing texting between healthcare providers about patients and between patients and healthcare providers. Self-service kiosks. You walk in, you don't see a person. You go up to a kiosk, check in. If you get one of these in your office, and I know it's not imminent as you're going to, it's in your waiting room. Can anybody tell me what physical safeguards they might want to think about the screen on that kiosk? Anyone? You have a waiting room full of people. Do you want that screen where it can be seen? So that's a physical safeguard on that information. Web portals, patients can get on the web, go to a secure website, pull their own records. Enforcement. This is really interesting. The Office of Civil Rights received about 7,000 complaints in 2010. In 2015, they received 18,000. It's gone up exponentially. Their cases in 2010 involved looking at complaints. It was one of the top things. Today, not even on the list. Why? Because the security rule came in 2013, the security rule came in 2013, the Office of Inspector General nailed HHS for not enforcing their own security rule. So how do they get their cases now? They get their cases from reports of data breaches. So if you've lost patient data and you report it to HHS, that pretty much automatically triggers an investigation, and almost all of their enforcement actions are coming from that now, and not the patient complaints. If it's an egregious patient complaint, it probably will result in an investigation, so don't start feeling comfortable about that. The top reasons for it are the data breaches, not having proper safeguards. Again, that's a result of the data breaches. And then you have access to health records. Remember, it's the patient's record. If they come in wanting a copy of their records, you need to get it to them. One of the interesting cases was a physician's office had a patient who was behind on their bills, and they came in and they wanted their records. And they said, you need to pay your bill up before we give you your records. The patient complained. The doctor's office was found in violation of HIPAA because that patient had an absolute right to get these records, regardless of how much money they owed to practice. Same thing as you can't really charge a fee for them to get those records. Oregon Health Systems. This was an interesting case where they self-reported a data breach. Office of Civil Rights came in and started looking at their entire HIPAA compliance system. And what they found was they were using cloud storage, just like I had talked about earlier, for their data. They didn't have a business associate agreement with the cloud storage provider. They had it encrypted before it went to the cloud storage, but that didn't matter because the cloud storage provider had it in hand. And they had one other problem, and that was a policy they didn't have the correct policies written down in place. And so what we learned from that is have a business associate agreement. Require the people that are coming into your office and working for you in any capacity to protect that information, protect that patient information. And another interesting thing is they were doing a required risk assessment. And they had the same risk assessment in 2003 that they were using in 2014, which was the last time they were there, 2013. Technology changes. Their system expanded. It got a lot bigger since 2003. The risk assessment no longer applied to it. There were huge gaps in entire sections of their system that they weren't even looking at with their risk assessment. Don't do this. Think about your compliance. Use your mind on it. How does the requirement apply to what I have now? Use thought. This is another common thing that results in data loss, and that is devices being stolen or lost. Cancer care employee had backup data on a laptop that was not encrypted, had the laptop in the car got broken into, laptop stolen, patient information for 55,000 patients gone. What's their potential fine? $50,000 per patient whose data was lost. So the potential, this is Indiana oncology practice. The potential fine that they're facing is $50,000 times 55,000 patients. That would put you out of business. They didn't get that. They got a $750,000 fine, which was a huge break. But a $750,000 fine would put any of our clinics in business. The problem was that they didn't really have any administrative procedures about who has access to the laptop. Where can the laptop go? Can it leave the practice? That's what OCR did. It is about documentation, and I talked about administrative policies and procedures. Compliance with HIPAA is about documentation. You have to document, written document that says this is our policy. This is how we train the employees on the policy. So it's about that documentation. That's what they look at. They don't basically come into the practice and just ask you verbal questions about it. They want to see the documents. And when they do their investigation, they want to say, okay, well, I want to see where you have your policies and procedures written down. That's what they're going to ask you. If you're required to be HIPAA compliant, you need to have those policies and procedures in writing. We collect data from you every year, or every time that you're recertified for sure, but, about the patient populations that you see, and we try and use that data to see where the three clinics in the state as a whole are going and what type of patients we're seeing. One of the things we're thinking about this year is what kind of data do we need to be collecting, and what message are we trying to convey with that data? What arguments are we trying to make? What are the useful arguments that benefit you, your clinics, getting funding for the clinics, maintaining the funding that we have for the clinics? What messages do we need to give to those sources of funding? What messages do we need to give about the relevance of our clinics? The impact that our clinics have within the community. The impact that our clinics have on other healthcare providers in the community. And benefits to them. We want you to be part of that discussion on shaping this data. But when that data comes to us, we want it to be anonymous. We don't want to hear about your patient from Beaufort, Wyoming. client, and you hire a subcontractor to anonymize your patient data for us. Anyone, what kind of agreement do you need to have with that subcontractor? If you hire an attorney to represent you in a matter where that attorney is going to see personal health care information of the patient, do you need the same business associate agreement?
Keyword here is hire.
Yeah.
Volunteer.
What, hire or volunteer? If I'm going to come in and represent you,
Your eyes
if my eyes are going to be on it, I should have a business associate agreement that says that I'm going to protect that patient information the same way that you do. Even with our client confidentiality, to be HIPAA compliant, we have to have that. I can't, even if I don't have it, I can't go talking about it. And, you know, our professional rules of professional responsibility, you're double protected. But to be HIPAA compliant, it doesn't matter that my rules of professional responsibility don't allow me to talk about that information. Another important thing, patient comes in, they want their records. What do you do? Give it to them, it's their records. You guys did learn something. I appreciate you taking the time to listen to me. If there are any questions, I'd love to answer.
Yeah, Jeff, I have a couple questions. With mobile devices, if it's personal, if it's the physician's personal phone, and they're looking at clinic data on that, is
Yeah.
that different versus if it was a phone owned by the clinic?
No, it's not. The key there is to have a policy in place about that. A lot of healthcare facilities will have a mobile device policy and mobile device, a department that monitors those mobile devices. More often than not, if you're dealing with hospitals, they're supplying them with a mobile device for that, and they're forbidding them to put this information on the personal devices. That's the most common solution to that. But the issues are with a phone especially, and if it's a personal phone, and you know, if your organization knows that that personal phone has got protected information on it, you don't know where that device is going. You don't have control over where that device is going. And so it's really kind of not a good idea to do that. It's a better idea to give them a tablet or an Android or something that stays there at the clinic, that stays, that has the physical protections of the walls of your facility.
Two more questions.
Okay.
There's a HIPAA, oh, good night. Here we go, Lana. Sounds like starts with.
Okay, it's gonna take 3 of us.
Okay. All right, Jeff and Lana, let's go. The HIPAA confidentiality statement that a patient signs, they do here.
Yeah.
So we all need to be doing that, right?
Yeah, I would still do it. As I said at the beginning of this, HIPAA is mostly about health insurance, and that's what true is. Most of us don't take health insurance, and we think of it that way. But when I said raise your hand if you help somebody get in the following transactions: enrollment or disenrollment from a third-party payer plan. Medicaid and Medicare are third-party payer plans. So if you have done that and regularly do that type of stuff, then HIPAA technically does apply to your clinic, and you need to follow. Basically, you need to get some help making sure that you are compliant. There's never been a case where OCR has come after a free insurance clinic. And so what we would have there is basically what they call a test case, which is does it really apply to us? And we don't want a test case. And you don't want to be the name on that test case, because it is going to be stressed beyond your wildest dreams. Okay?
Thank you.
All Patsy?
Okay, so I have a salesman who's trying to sell me secure email, secure fax, and all that. Obviously, I don't want to do these kind of tactics. What we're doing now is the only people we fax patient information to, or the hospital, or maybe the doctor's office. We don't email anything about patients unless we do it with Access Health, who's under the arm of the hospital, and they use secure. So are we covered?
Two exceptions to the security rule are fax and voice communications by telephone.
That's what I was worried about.
Okay, there's an exception to the security rule. The fax is a piece of paper, it's a paper document, and it is momentarily converted to electronics for the purpose of transfer. Not to get too technical on you, but basically there's an exemption for that transfer through the phone system. Okay? Not through the internet, but through the phone system. So if you're using fax technology that does like the fax to email and you know, basically faxing by scanning a PDF and then using your computer to do it, now you're security proof. Okay? But if you're using the old school fax, standalone fax machine, anything else?
Does an MOU take the place of a business associate agreement?
Is it what?
The memorandum of understanding?
If they sign it, it is basically considered a contract between you and them that says you're going to protect it. The important things there is that you hit all of the requirements of the business associate agreement in that document. And so it needs to be a requirement that they signed and entered into that agreement with you. Yes.
We have a PA that works for us that also works at the hospital. And if we get fax put away or lab mail or something like that, our office manager may text her while she's working at the hospital. That is there a better way to handle that? Because I worry about
162.502 is an exception in transactions. There are 12 different transactions that can bring you into it. And that is an exception for, you know, so in other words, if you're enrolling somebody in Medicaid, yeah, it is. But if you're making an electronic transmission for the purposes of enhancing the treatment of the patient, okay, that does not necessarily bring you into the realm of HIPAA. On the other hand, you know, let's talk about that later and let me get more information about it, and then I can guide you.
I guess what I was worried about is something happening in her phone, somebody in her phone.
Well, yeah, I mean, a good practice.
Her text messages.
A good practice is you're going to send it over there, and then you go ahead and send it, and leave a message.
That's what I thought.
Okay. And then when the message comes back, get it into some sort of secure format and delete the message. Because the phone's going to get lost at the table when you got to eat and these type of things. And you don't want that. So if you can add that security, go ahead.
Hey, Jeff, do you think, would you all like Jeff maybe to send out an email to the association if any of you are interested in doing some kind of a risk assessment in your office to make sure you're in compliance? Maybe you could do that, Jeff, or we could do like a 1, 2, 3, you know, ABC something, and then if there are certain consultants or lawyers or anybody we could use that could help us make sure that we're in compliance.
Time frame on this. Right now, I am doing a huge compliance project and risk assessment. Actually, we're doing a risk assessment now. Time frame on this would be the best time to do this is after I complete this particular project that I'm working on. I can then go back and take that risk assessment and kind of apply it more to the free clinics. And that would be, and the thing is that all of you are different, okay? And that's why I say think. okay? Because what works here doesn't work here. All of you are using different systems. Go ahead, Juan.
Can you talk briefly, because I know we've heard a lot about social media yesterday, and someone said something a minute ago about YouTube, et cetera, how this all, HIPAA also applies to any marketing, advertising, social media, any type of videos or anything else. I know I work with a lot of hospitals, and I have to be as HIPAA compliant in anything, what I do. I have to make sure I understand all the laws, rules, and regulations. But I think that's something because we'll tend to get very excited about a lot of different things that we can do, but being HIPAA compliant in everything that we do and getting this patient release forms, acceptances, and all those types of things, how important that is.
Well, if you're going to use actual patients in your advertising, who are going to be the stars of your advertising, rather than actors or other, just generic pictures of people, and if you're going to use actual patients, they give out information in that could lead to their identity. And a picture of somebody is a pretty good way to yeah, you're getting into the realm of, if you're an organization doing HIPAA applies, you would need to have everything in agreement in there with every one of your business associates, including the people who are doing your marketing, that they're going to be in compliance, and that they're not going to take that information without the proper permissions and proper forms in place, and just go blast it out there. And a lot of times, one of the problems we have with marketing is marketing people are, and this is good, they're fast-paced, they know that time is money, they want to get it out there now, okay? And there's you have to slow down with this. You have to slow down and you have to say, okay, well, how does this fit into the overall picture? And how does this fit into the overall regulations? Because it's not so much the marketing company that's going to get in trouble. It's going to be the healthcare provider. And they're the ones that are going to, if their business associate messes up, they're the ones that are going to take it. Anything else? Did I do okay with that?
You did great.
All right. Okay.
I have a question. I'm a newbie, but I did have a nurse to ask a question yesterday, my first day at work. And she has a concern about HIPAA compliance with us using the iCloud. It's a free program.
Yeah.
And residents from the local hospital have access from their hospital to those records online. And wanted to know, like, when a resident has completed a program, is there a way to discontinue? Do you want us to discontinue their access? Or what would you recommend in that situation?
I want to get more information about the specific stuff, and I want you
Okay.
to talk to me afterwards,
Okay,
and let's go through the specifics of that. In general, yeah, we've got off the access, but let's go into the big picture of how this is being used. Obviously, you have a cooperative system with the hospital.
yes.
And let's talk about big picture and how to put the responsibility of this onto the hospital too.
Okay,
And so that way you don't necessarily have to do it today, one of the two of you does.
okay, because they know when the resident leaves the program.
They have a lot more control over that than you do.
Yes, okay, great,
Okay. And they may already do it.
right,
Okay.
okay,
Generally, they're pretty good. They have some really good experts in the field.
yes.
I had a question over here.
This is related more to the patient privacy statements, and whether or not it's okay to just have them available in the clinic, available on the website, or is it best practice to have the patient sign those at the time of being a new patient with, say, example, annual signature?
I would, both, they can sign it and bring it in, but the main thing is that you need to document that, yes, we have it. And that's the key. I mean, and so be prepared to do both. If they come in without it, hand it to them, have them sign it right there. If they come in with it, if they downloaded it and printed it and signed it and bring it in, you know, that's good. One key thing is that you want to make sure that you're looking at it and you have something on there that says, yes, this is our form, some sort of indicator, and they're not bringing in some generic thing that may be old and no longer complies with the new requirements. So that's kind of a, you know, a lot of times if somebody's busy at the front desk and they're just handed a form, they check the box, yes, we have it. And then later on, when you need it, you go back and you look and you can't find it. So,
In regard to FTCA, those tort claims, we
Yeah.
have to give every patient notice of, you know, the Tort Claim Act and privacy. Does that encompass a business associate agreement, I mean, with FTCA? Perfect.
I don't know. You're getting above my head here. And I know a good bit about Tort Claims Act. I used to work with it a lot. I don't know what their specific requirements are. You have your HIPAA requirements, and to be compliant with HIPAA, you have to do these things. You also have a different set of requirements there. You have another set of requirements with the HITECH Act. And I know that the HITECH Act refers a lot to HIPAA. I don't, because it's been so long since I've worked with tort claims in healthcare. I used to when I was at the Attorney General's office, and that was, it seems like yesterday, but it's long enough to where I can't remember off the top of my head. Why don't you get with me afterwards? I'll give you contact information and I'll try to find out for you.
Okay, thank you.
Just one other thing, this year there will be, maybe even in 2016, we'll be publishing a new set of guidance and likely will include some of these electronic releases